were the result of the defendant herself breaking the windows, refusing access. The landlord is now going to be outside of the certificate of occupancy that was issued because repairs can't be made. They can't get access to the property. It continues to deteriorate. As a result, there's a broken window, broken doors on the interior, broken doors on the exterior. We filed a notice to have this terminated as a result of the health and safety hazard, as well as the non-payment of rent, and we'd be asking for a judgment at this time.
Response.
I have it prepared here. I will pull it up. Okay, this was what I received from attorney with the legal aid, Tracy Jensen. And there are several issues at hand, including procedural defenses. In regards to my written statement and the statements made by Attorney Babnick, the property is not damaged. The pictures that the landlord included, I have countered and included pictures of the house in its current condition. The house was inspected by the Ypsilanti Building Code, Miss Jamaica Berry, in October. In October, I also filed a formal complaint with the city of Ypsilanti through the C-Click Fix notification system, a governmental agency, of the issues with the habitability of the home. I have filed a case with the Fair Housing Administration. There are many things that we could focus on. I would like to focus on the fact that I was denied a disabled parking spot. And according to Michigan Legislature Section 600, and that is 600.5720, says that if it's an alleged termination was intended primarily as a penalty for the defendant's attempt to secure or enforce rights under the lease or agreement or under laws of state, governmental subdivision, or United States, they denied my handicap parking. I filed several complaints at the city level, and I'm defending myself here. The alleged termination, Part B, was intended primarily as a penalty for the defendant's complaint to the governmental authority with a report of the plaintiff's violation of a health or safety code or ordinance. The allegations made by the landlord, I wanted to bring in a third-party perspective. So I contacted the Ypsilanti Building Code Department. Ms. Jamaica came out and did an inspection and found 12 violations on the landlord's at the landlord's responsibility. In regards to the statement by Attorney Babnick that they have not been allowed to access the unit, that is so false. Her husband, Mitch Carrick, busted down the door, and I was not able to secure the unit.
This isn't the time for me to receive.
I think there are tribal issues, and I can.
Thank you.
Yes,
that's
sir.
all you needed to tell me. And when I look at that, then what I'm going to do is I'm going to do two things today. I'm going to set it for a final settlement conference on this. We'll hash out specifically what issues are going to be litigated. The parties are going to need to be ready to go to trial when I set the trial date at thereafter. All right. I'm also going to order regarding escrow, and I'm just going to say this to you, Ms. Kingsley, that you coming into court and posting escrow in $1 bills, this court views as just harassing my clerks and making my clerks go through that process. It is something that I'm not going to tolerate. There is no reason why you have to bring single dollar bills in. You did that when you paid the $111.11. You also did that when you paid $444.44, which my clerks had to count out. You also did that when you paid today the $666.66. So on my own motion, I'm going to order that as you post escrow, that you may only post escrow in denominations of U.S. currency, not less than $10 bills. It is further ordered that from you on this case because of your abuse of the process, and my clerk's office they are ordered to accept no $1 or $5 denominations of US currency for you for the purposes of escrow. And I have signed that order. We will present that to both parties. See everybody on March 19th.
Quickly, can the court inform me what's the registry of the court as far as the escrows?
There is a $111.11 posted by our records. It was posted on January 8th, 2024. On January 10th, 2024, there was posted $780. On January 22nd, 2024, there was posted $1.11. On February 5th, 2024, there was posted $444.44. And I think today, correct?
Yes.
Today, there was posted $666.66.
If I may, Your Honor,
Go ahead.
I just want to establish that I paid the full amount through February and there is a balance ready for March. This is not an issue of paying the rent.
My issue isn't with whether or not you pay rent. It isn't anything like that. Will not be trying to bring singles in, trying to make some point to my clerks. They have nothing to do with whatever the issues are here. They are here trying to serve the public. You will not hand them $600 worth of $1 bills for them to count out. It just won't happen. And I've issued that order.
Would you like any response to that, or we can just move forward?
You can make whatever response you want. I'm just telling you, don't bring any singles in here trying to post escrow. Don't bring any $5 bills trying to post escrow. $10 or higher.
Understood.
That's it.
Going forward, Your Honor.
Is there an adjourned date, Your Honor? I'm sorry, I didn't know.
March 19th, 2024, 9 a.m. in person.
Your Honor, if I may continue,
Thank you, Your Honor.
if I may.
Go ahead.
Right, so I did confirm with the clerk that all US accepted. Policy does not-
No longer on this case. That
Yes,
is my order. Thank you. I'm done.
We are done. Thank you, Your Honor. I understand. March 19th at what time?
9 a.m.
Thank you, Your Honor. Have a wonderful afternoon.
I will do. You do the same.
I will do my best. I am grateful.
Lines of Clover Lane versus Juan Brown.
Good afternoon, Judge. Carrie Zanin, P 67390 on behalf of plaintiff.
Juan Brown? You haven't checked it. No. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
I do. Your Honor, plaintiff, at this time, this is second or a third hearing. Plaintiff moves for default judgment. Rent to retain $6,014.67. Court costs of
All right. Your motion, sir.
File the motion for bond, Your Honor. I think the storyline of that motion, as the court can tell, is that Antoinette shouldn't have done it. She's sorry that she did it. It's not going to happen again.
I apologize. It was honestly a big mistake.
It was obviously a very big mistake, Your Honor. It was a poor decision. I mean, she wished she could go back in time and stop it, but she can't. She's tried to take some proactive actions, deactivating her social media account. She turned herself in the next day. She called the police and said, I have a warrant. I need to be turned in. So I am heartened by that, Your Honor. A lot of people, when faced with a warrant, they leave and they don't come back for months and months and months. Antoinette made the right decision by turning herself in. She's been there for a couple of weeks now. I mean, she's had some time to reflect on it. The way she expressed her feelings about the case
What's wrong?
was wrong. It was inappropriate to do that.
I mean, I was sleeping with this lady, Your Honor, and I didn't know nothing about this case. Like, and it's like, I was frustrated. And I just felt like it was wrong for her not to tell me that I had this case on me.
There's a lot of frustration there, Your Honor, as the court can tell. And we got the video. I think, so the video was actually taken back in December. I don't know that at the time, I mean, that there was a no contact order between her and the mom. There is now. And she is absolutely going to respect that 100%. She's going to respect the social media, no social media 100%. She deactivated her Facebook, which I think is a step in the right direction. And she is very much feeling the sting and the reality of what happens when you air out business that shouldn't be aired out, Your Honor. That was something that she did that she can come before the court and say, I'm absolutely not going to do that again. She's hoping that this court will give her a second chance to be out there, to follow the rules. She has worked a job now for 11 years. She can still work the job if she gets out. But I think if she's in for a long time, it's not going to be there forever. She's been sitting there for 2 weeks, Your Honor, thinking, I shouldn't have done that. And I think she's coming to the court in a place where she's not going to make that same decision again, Your Honor.
Your Honor, this is one of those times where I'm actually at a loss for words. This is completely appalling. This is far beyond frustration. This is cruelty. It's re-victimizing a child and her mother. It's disgusting, quite frankly. I'm going to leave the rest of the court. Mr. Burton has done a fine job with this motion. I think the fact that she has worked for a school district, and to my understanding, unless I'm mistaken, is planning on going back to support her children is disturbing. This woman should be nowhere near children, given the nature of her offense. But with that, Your Honor, I will leave it to the court. I think I've made my case clear.
Yes, you did. Do you remember when the accusations regarding Facebook and other things came up at the court hearing?
Me or Ms. Evans, Your Honor?
Yeah, either of you. You were both.
Oh, no, the video
Yes, I
was from
remember.
December 26th.
Well, but there was a question. The
I didn't-
accusation came up. And it was basically directly put forth to you from me as to whether or not that had occurred.
May I say something? Well, I did.
And
Sorry.
hold on. And either directly, I mean, I can go back and get it, either directly or certainly by implication, it was said that it did not occur. That people's addresses, other things weren't put out there.
Yes, sir.
And I can see in my mind's eye your face as you were telling me that. And I remember you kind of walking out, kind of smugly and just so self-assured that you had just gotten away with something. And
No, I knew. I knew. I'm sorry. Sorry.
And then with a matter of minutes, I received the video. I'm going to be honest with you, I was angry. Because I believe that you purposely misled the court. And you're lucky you have the attorney that you do, because otherwise I was just sending people to get you.
Oh, no, I was going to turn myself.
No. You didn't even know there was a warrant out. By the time I got that video, I was just going to send people to find you and tell no one. Because you out and out misled this court. Let the court wrap up first.
Yes, sir.
Anything else you want to say?
I think Ms. Evans would like to address the court, Your Honor.
Well, Your Honor, when I did go, I didn't know if I should have said yes or no. When I did go on live, I didn't know that the video got screen recorded. It was off, so I didn't know if it was a video. I knew it was a video. I didn't know if it was still on there. It got screen recorded. That's how the video was still going around. But I made that video December 26th, which I wasn't talking about the kid, none of the victims. I was talking about the mother in this case, who I had a relationship with.
Say, sir.
I really do apologize. I mean, I didn't know it's gonna cause me to go to jail.
Oh, no, you were sure that day you had gotten away with it.
No,
Yeah, you were. Ma'am, I watched you as you walked out of this
I was
courtroom.
nervous. I was scared. Like, I don't know if it was
No,
a video.
no. You know what? Let me tell you something. You can try to play a game with me if you want.
Uh-huh.
I watched exactly how you walked out of this courtroom, like you had gotten away with something. And when that video came in, it would be one thing, and I usually give people the benefit of the doubt. If you had been mistaken about something, if you had, then fine. I'll give you that benefit of the doubt.
Yes, sir.
But there is no doubt in my mind that day, you just felt so self-assured that nobody was going to find out. Nobody was going to do anything. I'm not getting caught. I'm not doing this. And like I said, within a matter of minutes, that video shows up.
Yes, sir.
So you can sit there in your head and play this game with yourself about you didn't mean to do this, or you didn't know this, or you didn't know that. You can do that if you want. The reality is you got caught. And if you remember my warning to you, as I said, if there is a video, because the people didn't know for sure that I was going to issue a bench warrant. You remember me saying that?
Sure.
Well, the one thing that you'll know about me is I'm a man of my word. And that's exactly what I did. Motion for bond reduction is denied. Defendant's bond will remain as, the motion is denied. Defendant's bond will remain as denied in this case. We need to set it for a new date. I have this one set for, what date is it set?
I believe it's February 15th.
Judge, given her status, we just set this for prelim date.
You got all the discovery?
Well, I have the paper reports, so I'm confident I have what they can provide me, yes.
Okay.
I'll be ready to proceed.
Pardon?
We're ready to move forward, yes, Your Honor.
People, can you have your witnesses available the 6th or the 13th or the 20th, which would be
I know that the 6th, the 15th, or the 20th.
6th, the 13th, or the 20th.